And what is the issue here now? A very interesting episode now. In fact, here the law will come into picture, and every one of you will have to look at the Arbitration and Conciliation Act. That is how this training program is designed to learn. So later on you will learn. And then claim number 5, whether interest on claims, ante-like, pendenty-like and future interest can be granted, and also costs, and if so, what should be the rate of interest awarded. Decide in accordance interest for each of the periods and composition of cost. Decide in accordance with the provisions of Arbitration and Conciliation Act. So here 31 speaks of ante-like, means from the date of cause of action till the date of filing the case. Pendenty-like means during starting of and then filing of the case and closing. Future means from the date of award till the date of realization. Costs, they are all stated. What is cost, composition? Let us listen to claimants, how they articulate and then how they project it. Accordingly, you decide. As you forget what happened now, you have to start afresh. With a fresh mind, you will have to understand the subject matter. So, what is the first step? Presiding arbitrator. Who is your presiding arbitrator?
Contractor.
Yes, ma'am.
Yeah. Interest on claims, ante-like, pendent-like and future interest at 24% till realization. The respondent has blocked the claimant's finances as submitted in the foregoing paragraph. This has affected the client's turnover in business. Had the respondent paid the claimant his dues on the due dates, the claimant would have effectively and profitably rotated the money in business and earned more profit, leave alone the interest that it would have fetched. The claimant seeks compensation for this loss in the shape of interest at 24% on claim amounts from due dates till realization. Claimant has started its business, and please refer page number 7. The agreement was entered into by the parties was on 25th March 1994 without much delay. 1 month is the reasonable period to commence the business. So here date of commencement was 9th April 1994. So claimant did not take much delay. It is a very reasonable period to commence. So we are in time to commence it. And so the stipulated date of completion was 8th December 1995. Because of delay in payments, please refer page number 30, wherein delayed payments were notified. Sorry, 32. Payments on amount. Date of payment and amount paid. August 94 was the first payment made by the respondent, the department. By that time, the value of work done was 3,69,681, but the amount was paid only 1,89,335. Here, about 40% of the work done was retained by the respondent, paying for the further proceedings. The contractor could not bring amounts for further investments, And by 28th April 1995, 14 lakhs has been brought in as investment into the business. But the amount was not paid in time. However, 5,95,473 only was cash inflow to the contract. So approximately out of 18.5 lakhs, only 6 lakhs, about 30% amount only has been received by the client. So from 94 to 97, this blocked investment has to be calculated, future values, time value of money has to be considered, and from such period, the claimant is requesting the Honorable Tribunal to consider the delay from respondent and grant relief in this. Further to it, please, I would like to draw the attention of Tribunal at page number 14. So net amount was 1,80,254 that been received by the claimant on 29 August 94. Thereafter, we had no payments in 7 months. For all these 7 months, the contractor borrowed monies, paid interest for about 2 years, for complete 2 years. And subsequent to it, having further invested, 10 months delay was caused. So because of these delays, the interest was claimed, and however, the claimant seeks compensation for this loss in shape of interest at 24% of the claim. Yeah, I'm ready for the next.
So, I'm Manara speaking. So, I'm representing the claimant. So, here the claimant has suffered a huge loss because of delay in making payments by the respondent. And in support of that, we filed before this tribunal C1 on pay number 17. So here the letter addressed to claimant by the respondent, you are requested to speed up the progress of the above slash complete by 31/3/1996 that the funds have been allotted. Since the many payment delay, so after they are not able to pay in the due dates of the bills, later when the budget sanctioned, they asked this claimant to speed the work. So since there was no progress in the construction because of delay made by this respondent making payment, so the delay was extended to after getting this letter, and again exhibit sheet was filed before this tribunal, which is on pay number 18. So which is mentioned by this respondent addressed to the claimant. Payment due on running account bills. You are in receipt of your several letters of the agreement for building construction. They are executed on which payments were not made. All of efforts have been made at various levels for release of adequate funds for ongoing works with the Department of Force. It is expected that the Planning Commission will release adequate funds in the next 2 months to clear the liabilities. So they mentioned 2 months, but do not materialize upwards. But they took abnormal delay in making payments to the claimant. So that is the reason we request the tribunal grant that arbitrator may kindly be pleased to award interest of the rate of 24% annualized and then late and first award and claim amounts till the date of realization.
24%.
Yes. So I am asking. Next to my colleague.
Myself, Friend has already read.
What again?
She has read the friend.
Page 15,
Yeah.
claim number 5. I want you to read that.
Okay. This claim number 5, interest on claim.
Page 15, claim number 5. Please see. It is not for me, sir. It is for you.
Yeah. Claim number 5, interest on claim, anti-light, pentalite, future interest at the rate of 20%
Yes.
realization.
Let everybody know what exactly you pleaded.
With the permission of this tribunal, I want to highlight one of the observation given by the Supreme Court, which I have already shared on a group, which can be seen. It is
I request you to read page 15, 3.5.5 to 3.5.2. Please observe. Please read it again.
3.5.2.
5.1, sir.
Start from 3
Respondent has blocked the finance as submitted in the foregoing paras. This has affected the claimant's turnover on business. Had the respondent paid the claimant his dues on a due date, the claimant would have effectively and profitably loaded the money in the business and earn more profit, leave alone the interest that it would be fetched. The claimant seeks the compensation for the loss in the shape of interest at the rate of 24% on claim amount from the due date till realization.
I hope now you understand.
With the permission of this appellate tribunal, I want to draw your attention to the para which have been shared with the group, wherein in the
What is
case,
the judgment, sir?
it's a judgment of Food Corporation of India versus AM Ahmad and Company,
CA versus?
AM Ahmad and Company, Air 2007 SC 829,
EIR?
SC 829,
EIR 2000?
7 SC
SC
829.
829.
Yeah.
Right, sir. You have posted it?
I have posted the article which I am reading right now.
You have posted the judgment in the group.
The observation I have already shared.
It is the ratio and the comments which.
But the judgment is not posted.
No.
Okay.
In the-
Articles cannot be submitted for adjudication before the tribunals or courts, even arbitration also. You are relying upon it. Underlying it can produce a judgment, but no articles.
Yeah. Right now I am just sharing what observation Supreme Court has drawn.
Without judgment is given, some article, the article may go wrong. How can you rely upon an article?
It may have author's views.
We don't know. It may be other specific too.
Weakest one.
So you have to give, this judgment is there. You could have taken the copy of the judgment and circulated in the WhatsApp.
Okay. Currently I am not having that one.
You can do that by right now, when they are arguing,
At that time I will share.
you can share it.
Yeah. Shall I read it right now or no?
The judgment
Yeah.
part you read.
Okay. In a Food Corporation of India versus AM Ahmad and Company, wherein the subject matter related to the performance of the contract between the period from the date 8/4/1981 to 7/4/1983, 20 years